tolerance and principles of peace. We are coming together over a noble cause, establishing foundations. All society, regardless of culture, religion, or geography. Indeed, this is a very good occasion on which IAIS and various other organizations will be joining hands to do some work that will be of benefit to all of us. Hopefully, in this world, the multi-dimensional, as it is in fact indicated from the participants that we have, we will be addressing this subject of their angle of expertise and experience. We have been asked to address this to focus on developing the Maqasidi from the Islamic perspective. And that is the nature of my second part of the discussion. I will go directly. The subject of my presentation is to develop a research framework on child-sensitive social protection in Malaysia. Maqasidi Maqasidi have become the subject of renewed attention among Muslim scholars and researchers in recent decades. It is an important subject because it is concerned with the purposes of things, the purposes and the objectives that we identify and we form. Maqasid is the plural of maqsad, purpose or meaning, and it is the same in Malay, maqsood. It was not, it is a subject that is evidently important. So when you look at the Quran and Sunnah in Islamic tradition, it is said, scholars have said that initially it was said that there are 200 references in the Quran to the purposes of things, but this was revised by Ibrahim al-Shatibi, saying more than 1,000 places in the Quran that the Quran is very purpose-oriented. And so this was 6 centuries after the development of the science of usul al-fiqh, the science of the sources of law, the usul al-fiqh, which is the subject of ijtihad. When a scholar of Sharia decides to derive the ruling of a new issue from the sources of Sharia, you will be looking at certain sources of Quran and Sunnah and general consensus and maslaha, that is public benefit and so on. But in that range, if you look at the classical text of al-fiqh, the Maqasid is not even mentioned. And it was not until 8 centuries that al-Shatibi, in his famous work al-Muwafaqat, addressed the Maqasid and developed it in a distinctive chapter in understanding of it refers to the meanings and purposes that the lawgiver has intended behind the rulings of the Sharia. There are some differences in the definition. Some would say that every rule of Sharia has its purpose. Nothing is purposeless. And that the entire Sharia consists of 2 main parts: the maqasid and the wasail, the purposes and the means toward realizing those purposes. I will be explaining a little bit about what we make out of the Maqasidi approach, but will be contextualizing myself later in the subject of this research. It is to generate general understanding of the Muslim life. It is, of course, naturally important to look at the purposes of whatever it is, whether it is the rules of Sharia or the kind of activity or purpose that we seek to develop in the course. It's the primary question: what is the purpose of doing this? And to ask those questions in the context of Sharia has been somehow discouraged over a long period of history because it verges into philosophy. What is the purpose of lawgiver validating this particular rule or that particular rule? What if that does not agree the answer that you find with your own rationality, your own thinking? Are you then also accepting it or not accepting it? The Islamic tradition is known for its literalist orientation. Looking at the text, words in meaning, sentences of the text, introduction, the Quran, the Sunnah, and deriving certain rules from that, but not asking the question, what are the purposes and intentions of ruling? It is somehow the ulama, the scholars of fiqh thought it to be inappropriate, not in fitness with the spirit of submission that a Muslim must have, to go into the why and how. We ought to accept the outcome of the Sharia as they are. That was the kind of the time gap. We still, it will be in the 20th century that the Maqasid has been added as a distinctive chapter into the studies of Sharia. And now there are conferences and PhD researches and constantly. The reason for this revival is renewal of interest in the Maqasid is that it is immediately concerned with values that are meaningful to society. The Maqasid are divided into several categories and the discipline in its own right. One of the classification of Maqasid is the essential purposes, Maqasid Ururiya, complementary purposes, those that are complementary in the second order, and then those that are desirable. The essential Maqasid speaks of the protection of life, protection of faith, protection of rationality and intellect, the integrity of human judgment, and protection of property and that of the family and progeny. From just a simple meaning, you will see that there is immediate relevance to the values that are meaningful to all of us, society. But as you see, we are not really following it even to this day, the purposes of the ahkam of Sharia. When you look at this debate about the hudud must be applied as they are, understanding at this day. Punishment for the sake of punishment for a certain number of crimes. But they don't hardly ask the question, what is the purpose of that punishment? Is it justice or is it just punishment for the sake of punishment? If the purpose of any punishment is to serve justice, then you are to change your agenda in places where those punishments do not serve the purpose of justice, then you should be able to judge and not to apply. This has been the case during the time of the second Caliph, Umar ibn al-Khattab. There was a year of drought in Medina, and food supply became very short. And he suspended the hard punishment of death because those who steal due to starvation and hunger, who apply that punishment to them, this would defeat the purpose of justice. The same was done by the Prophet himself in times of engagement in warfare with the enemy. You do not apply the punishment of wine drinking to peaceful people because the purpose of alienating our warriors for this kind of misgivings would enable defeating or joining the enemy side. The harm would be much greater than the benefit of punishment or something. These kind of things have been done in the past, but our jurists and scholars and muftis, they are not really very receptive to the idea. We are still talking about the Maqasidi as a moralist and a theoretical discipline. There is a distance. You offer this kind of argument to the judges today. They will apply, this is the Shafi Mazhab, and this is the ruling, and this is what it is. They don't look into that. But this is a great neglect of the Sharia itself, because the Sharia is, it comes with meaning and purpose. If you sacrifice those with the letter of this approach, then you are not doing justice to what you are doing. So there has been a historical neglect of this discipline. What the fiqh tradition, the Islamic law that we have, a very rich legacy that we have, like in the Hanafi school, Shamsuddin al-Sarafi has written, articulated the Hanafi fiqh in 32 volumes. And there are people in the Arabic developments that have been with us, this kind of, monumental scholars developed from certain perspectives. But it's not very easy to get away from history, will not leave us even if we want to leave it behind. So we have to respect what they have done, but to read it from an angle that is meaningful to us in this society. When you look to the Maqasid, the purposes of things, then you ask the question that the purposes of this generation in the 21st century of the Muslim Ummah, are they the same as they were in the 6th or 7th or 9th century? The society has changed so much. There are changes inflicted upon us by science and technology and modernity, secularism and globalization, and you name it. Can you turn your back on this? It's impossible. Therefore, you must read that discipline, the fiqh itself, from the from a purposeful angle, but be also able to integrate into it the conditions of the society in which you live, like the use of gadgets, for example, the use of technology, the kind of pressures that the modern generations is exposed to in the materialist society and culture, and the capitalist kind of setting in which we live. And here comes a question of how you compromise those. We cannot sacrifice ourselves entirely to this. So the task of the scholar is to read all of these influences, and in addition to that, what our constitution and our laws and our ministry policies and what else you have. All of this must be put together and developed into a framework that is meaningful to you for the purpose of helping the children, our society, to protect them against the kind of influences that we know are happening, and they are happening at an increasing pace. Unfortunately, children are exposed to a variety of abuses, starting from the family, then society, sexual abuse, violence within the school setting, bullying, for example, teacher and parent relationships, and the kind of issues that you have. And there is now this coming together of these purposes and bringing us around this table to find the best ways that we can address this. From the Maqasid perspective, it is not just the purpose, following a purpose in an affirmative way. That is the purpose of protecting religion or protecting property or protecting the family. These are the affirmative, positive aspects of the Maqasid. I have 5 minutes. But the Maqasid also means that we must fight the evils and the negative influences that are affecting our ability to follow those affirmative purposes. Like there is a legal maxim of fiqh, Dar'ul mafasid awla min jalbil masalih. That is, that prevention of harm takes priority over the attraction of benefit. If you cannot fight an evil, a social mischief, your ability to be affirmatively engaged into those maqasid are negatively affected. That is why protection of harm and harmful influences takes priority. How are the maqasid identified? This is one major question that has occupied. The short answer to that is that you look at the Quran and the Sunnah and the general consensus. If you do not find your replies, what is the purpose of this law or that ruling or this ministry policy or that, and then you construct your own understanding of that through ijtihad. These are the 3 ways that the ulama have specified. But what are the best ways? We said that the Sharia is divided into maqasid and wasa'il. What are the best ways of protecting those values This is something that is open to our innovation, that we can find the best ways how we protect the children through the avenues of this engagement into the Maqasid. One question we may ask to begin with: who is a child in this country? The law will give you a certain answer, but they say the Sharia gives a different answer, and this is a problem. Why do you read the law in the Sharia as two separate entities? And nowadays we are trying in the Muslim world to, once the law that is passed by our elected parliament, and those elected parliament include scholars of all disciplines, and sometimes they have expert committees on Sharia, on other, they recommend, and that law passes the stages and becomes authoritative ruling in document. Then you say that the law says one thing in the Sharia says. This question, I was a constitution commissioner 10 years ago in Afghanistan, and we formulated the initial text of that constitution. One of our tasks was to consult the community. One day we invited the scholars, the ulama. In the morning we invited the Sunni ulama of Kabul, in the afternoon the Shia ulama. And they started lecturing us, 15 of them, instead of explaining what is their expectation of this new constitution, what are their advices for us. And they started telling us that our youth, our women have lost their ways and this and that and the other. The Sharia is one thing in the constitution, so we want a total Islamic this and that constitution. And I listened. No one would really oppose them, but after that I took turn. I said, you draw this distinction between the Sharia and Constitution. The Quran itself says that you must obey the Quran, Sunnah, and the Ulul Amr. And who are your Ulul Amr in this country? This is the parliament and the president, and what they say already the Sharia is integrated into it. So the constitution becomes the hukum of the ulul amr. And that is one reality you deny. The other is that the women of Afghanistan, the world outside know, are the most oppressed. And we have not recognized the ways how our ulama communicate with the youth. Have you communicated with women? Have you sat to listen to them? And there was this kind of, and one by one I conveyed how I understood. I said, you came here we asked you to come here for a purpose, but you have not said what we expected you. Instead that was the kind of setting we have, and I think Afghanistan is not a totally isolated environment in that respect. I think that there are different ways. Guardianship, marriage guardianship is a trust. In fact, there is nothing in the Quran on the subject of wilayatul nikah. It is a juristic construct. The Quran and Sunnah does not say anything whether there is something like wilaya and nikah. There is wilaya for a child, a minor person, but that is for a certain need. When the child is in need of protection, of guardianship, then that is the job of the guardian to serve that purpose. With regard to child marriage, this became a menace in our society. No, in Malaysia, you don't have it in its worst form. You have it in many different, very, very oppressive varieties outside in Asia, in Africa, and so on. It has become a social mischief, so much so that laws and legislation have been formulated, passed to address this, but it is something also entrenched in society. It's very difficult to uproot. Now, the wilaya of in nikah, the father and the grandfather has the wilayatul ijbar, compulsory guardianship power to give the child into marriage. Now this is an issue that aroused different responses from the mazahib. For that you must recognize what is the age. The age issue is there are different ages in the fiqh. From the age of discernment, age of tamiz, 7 years. Age of puberty is 9 years. Age of majority, which is accepted, 15 years. Age of maturity for signing contracts and transactions, 18, according to some 21. There is no fixed age, but it was during the Ottoman times that age of 15 was considered to be the age of majority. Now in this country, the law says the age of majority is 18, and it doesn't serve the purpose of protecting the child. So anyone below 18, the guardian is within his rights by looking at the fiqh rules, the Shafi'i fiqh or other fiqh, to give this into marriage, and no one can oppose them. No, it must be opposed. You must read the law in the Sharia together. If we say that this guardianship power, كلكم راع وكلكم مسؤول عن رعيته. This is the Prophet. Every one of you is like a shepherd, is a trustee that is under duty to observe their trust. And this is everyone in society and everyone that we have in a role. Wilaya or guardianship is a trust. And early scholars, I will soon finish, some Mu'tazila scholars, Abu Bakr al-Aswam and Ibn Shubraba, they went on record in the 2nd century Hijrah that child marriage is not valid. There is no need for it because a child has no need of marriage. A child may have some other needs, but this is not one of them. And therefore, we open the way to abuse and we do not consider it valid. There is nothing in the Quran, and we have no incidents in the Sunnah of the Prophet of exercising this kind of guardianship in marriage. But others have accepted this. Now we have this case of an 11-year-old child accepting that. The child says, yes, I'm happy with it, but you're not qualified to express this. Marriage is not such a thing that you can, ratify in that way. Only when you are above 18 you can say that. So to say that this is valid, it is not an abuse of the power of guardianship, it's not accurate. Looking at it from the Maqasidi perspective, from a kind of constructed reading of your fiqh tradition, it is the task of the scholar and mujtahid of today to read these influences and protect the child from these abusive incidents. Someone goes, because the law of Malaysia does not allow it, they go to Thailand.
Yeah.
And they sit and they conclude a child marriage. They come back to Malaysia. In Malaysia, they fine them 1,800 ringgit. That's the end of the story. And then someone says that we cannot do anything about it because the Sharia says, yes, you are the government. You must do something. You must protect the children. And look at it again. Luckily, this attention has been drawn. The ministry, they said that they will develop standard operational procedures for this kind of, marriages, and there will be a new look at the situation. So that is what we stand, and we will join hands with what is happening, hopefully in a meaningful way. And we are fortunate that representatives from the Ministry of Women and Development, from other entities, they are all together, and we will be having a comprehensive and fruitful discussion. I have exceeded my time. Thank you. Assalamu alaikum.